I'm very excited. Very excited about this one. It was sort of fun to put together and think about all the things that you can do wrong in wills, which I really try to avoid doing. So some of you have seen this. I mean, I just sort of start out the same way. I'm Beverly Carter. I'm a notary public. I've been commissioned for just over 7 years. I bring a lot of wealth of experience into my practice. I say I have 3 PhDs in life, and I really mean that. So, but it helps me every day when I'm talking with people to do what I do. But I also have my other roles in life, social roles as a wife, mom, mother to sumo, and all that kind of stuff. So introduction just to my staff. There we are. And then I've got Alicia, so she's sitting with me. So some of you have met her before. So she's helping me out because I love technology. I just don't ask me to set it up and figure it out. But I can look good. Housekeeping items. So you please use that chat option throughout the session. And if you find this valuable, please do share it with friends and family, either the invitations, but we are actually posting on YouTube these sessions so that people can watch them at different times. They don't have to sign in. I do like the engagement with people live, but I'm open to offer these more if you have workplaces where you think there's a group of people who would be open to this. Today, these are the main documents that we talk about. We've already been through the health representation agreements, powers of attorney, advanced directives under health. And today we're talking about the wills. This is just sort of a little plug for our next Lunch and Learn topic, which is estate and emergency planning workbook. And if you go onto the website, you'll see the details of that. I have a special guest. Actually, it will be my brother. He actually has a career in emergency planning. He's worked in the forest firefighting in BC for over 2 decades. And certainly has some really interesting experience about emergencies happen. Anyhow, and he's good and fun. So, but I won't keep him on for too long because, just because he's my brother. Today's topics. So these were kind of the areas that we were going to cover: the issues with do-it-yourself wills, common errors that people make, why having a will done with a professional matters in BC particularly. I'll review some unique features of our Wills, Estates, and Succession Act, weave that into the stories as I'm going through, and then just general estate planning and how to prepare for making a will for yourself. I thought I'd start with a lot of the common questions that I get. These may come in person or over the phone that staff have, or somebody pops into the office. A common one is, can a notary do a will? And yes, in BC, notaries can do wills for about 75% of the people. We're not the same as a lawyer. We are legislated under a different law, and we do have some restrictions, and that's where that 25% matters. Lawyers can do some more complex trusts that we can't do. So just to give you an example, when we're doing the trusts that we are limited to do at this time relate to minors. And so either when a child is aging out at 19 or when a group of children, the youngest turns 19, then they can get their inheritance. So that just in a nutshell, in terms of wills, is one of the difference. But and why should you use a notary or lawyer instead of a do-it-yourself will? Well, I'm going to talk about that. Comments that I get is, my will is simple, my will is straightforward, I don't have anything, I'm giving everything to my sister, she can give it to everyone else, I've done my own will, I just need you, the notary, to sign it. And so I'll kind of weave in the simple and straightforward. I don't have anything. Most people have something, and so that matters. Even if you just have a bank account and a car, in a will you appoint your executor, and they're the personal representative from the moment of death. In the absence of a will, you don't have that, and that causes some challenges. Giving everything to somebody else to distribute, well, what if they don't? So And then I've done my own will. I just need you to sign it. We never sign anybody else's homemade wills because my insurance coverage for one wouldn't cover it off, and we haven't done our due diligence around that person or understood their context of their life. So I just thought that was interesting because these continually are still common questions and comments. So how many people have wills? So just over 2 years ago, an Angus Reid poll found that 51% Canadians don't have a will. I've put a link to that. So it's interesting, actually, if you go in and look at that, there's a whole lot of other details that they go on, and they'll talk in and about what's going on in BC. And, but lately, because of COVID-19 and beyond, I'm going to guess a whole lot more people have wills now. Interesting here. So here's a comment that came about a month ago in the Times Colonist, where they ran an article about the surge in demand for homemade wills or do-it-yourself kits. And that follows on the heels of Tom Hanks and the NBA shutting down, which is interesting because I think then people said, hey, this is real. So that's really, in my world, the pivot time too. You get a sense of their growth in their sales. I'm sure they're happy dancing. I can certainly say in-house, the phone was just ringing off the hook. I couldn't really accommodate a lot of the demand. We did our best, but it was pretty not like anything I've ever seen before. So are those COVID-19 do-it-yourself wills good? And that's a lot of what we're talking about today. And why would we ask that question? Because it really matters, because there's a whole lot of issues that happen with do-it-yourself wills. You'll often see these marketed as DIY wills, will kits, online wills, digital wills, free last wills. I've seen things promoted as a freebie or a value added for some other service, like funeral homes will sometimes offer that, as well as charitable organizations. And the lawyer who made this particular comment, I actually just got off of the phone with about 10 minutes before starting this call. Lawyers love homemade wills, and it was entirely re-emphasized, that comment. And essentially, she said, at minimum, she said, there's almost never been a homemade will that she hadn't touched where they didn't have to have some sort of a court resolution. And she said in today's terms, at minimum, $5,000 to $7,000 just to get into a court to deal with an issue. And that doesn't include, you know, all the other issues that come up with that, which I'll talk about on another slide. But expense should be your biggest reason why you don't want to do your own will, because the cost is much greater in many ways. I thought I had a good laugh about this. Oops, I can't really read it because something's in my thing, but it says, apparently the will was typed up wrong, and UCLA got all your husband's money and you got his brains. So I thought that was kind of cute to emphasize that errors can be made. And I'm just going to say I saw a homemade will I reviewed a month ago that some clients had done on their own about 3 or 4 years ago. And what they wanted to do is not actually what they did. So they had decided that 50% was going to go to, they had no kids. So 50% was going to go to one side of the family and 50% was going to go to the other side of the family. But instead they went 50% to this side of the family, and the other 50% went back to that other side. They didn't realize they had made an error, and they duplicated that error. I said, you know what? It's a good thing you're here today. So that's a very recent example. And I'm going to say at least 4 out of 5 wills all have grievous errors that I review. See, these are some common mistakes. Choosing a bad executor, and that can be for different reasons. You know, bad doesn't mean they're a bad person. But sometimes they can be inefficient. I've put a link just down below to a Globe and Mail article, which is one of the better ones that I've seen. It's from about a year ago, maybe 13 or 14 months. But it talks about appointing people from the US. So a bad executor or a bad choice of executor is probably a better way to put that, would be somebody in another jurisdiction. We know that there are problematic challenges between the US and Canada, and it has to do with the trustee laws, and somebody there essentially may have to, as a trustee, you're given everything. And in so doing, you then have to, in their own income taxes, they may have to claim that they own something in another country. But in fact, they don't really own it. They just own it in trust. And that's sort of the crux of the problem. And it depends on state to state and all that stuff. So I give that as one example. Sometimes people will choose the executor, they'll choose the oldest child in the family. I'm always one for choose the right person, the person who's capable of doing that. And sometimes family members are not it. Or your first choice might be good, but who would your second choice be? Other common mistakes are forgetting about the kids. I've had clients who are estranged, as an example, and in the course of a conversation with them, you kind of, you're flagged to the fact that there's some other information that's missing, and you find out that they in fact have a child from a previous relationship and haven't seen them for 40 years, don't know where on earth that they are. But that matters in the world, because these are people that are possibly in a position to challenge your will. And so forgetting about them or just disinheriting them can incur a lot of problems and subject your will to a variation claim. Forgetting about assets. Assets are really interesting, because I find a lot of people don't really understand the nature of how they own their assets. They want to give something, but it might be a direct beneficiary to somebody else. It's like, well, I want that life insurance policy. So they're thinking in terms of everything going through the will, but in fact, there are different ways that wealth transfers. Wealth transfers, life insurance, direct beneficiary, RRSPs, TFSAs, RESPs, you name it, those sorts of products. And so in the context of talking to a person, you know, knowing and understanding what those assets are, how they're held, are they held jointly, really matters, because you can't do everything in a will that you want to do. Sometimes you have to look about other strategies for gifting to people. A common way that scenario that I'll find is a lot of younger people with young families will be very heavy on debt, but very heavy on direct beneficiary policies like life insurance policies. And so, you know, they may own a house that's $800,000, but they have a $700,000 mortgage. So they may have, and they own that jointly, but they may have $2 million in life insurance policies. So really understanding assets matters. And the do-it-yourself people, you know, often aren't thinking in depth about these different aspects of their estate, because the will is really just one of the ways to transfer your assets. But it does other things. I'll talk about that in a separate slide. You know, you have to look at the whole of the person, because there can be tax implications incurred through an RSP, but you don't have money in your estate. So really understanding what you can and cannot do in your will makes sense, or planning ahead to make sure you can do what you want in the will by using other financial products to achieve your objectives of giving to who you want to give. Forgetting the details, you know, gifting maybe the family cabin and getting the details wrong about it, or the location. You know, these things can frustrate terms of a will and call it into question. Getting the facts wrong, well, not everybody knows everything, you know, who's who. Not using full accurate names. Common mistakes, signed incorrectly, so there are requirements to sign with 2 witnesses. I've seen wills people have done and they go, oh, I just did this before I was flying off to go somewhere just to have it in place, and they signed it, nobody else signed it. I've seen that multiple times. Giving assets to that you don't have or have the right to give. So a common one that I see here is people, blended families, for example, will have, and blended families will be two people who've come together, either common law or technically married, and they buy a house together and they buy it jointly. And I frequently hear, but I want to give my half of the house to my kids. Well, it doesn't work that way when you own jointly. Joint means right of survivorship. So when the first person dies, it stays in the name of the second person. So a lot of people think they can give the house, but it doesn't work. And so they'll add in a lot of detail around what they want, and they'll create trusts, they'll create ambiguities, and in essence, it won't get to what they want it to be. They won't get to the person that they want it to go to. Giving to the wrong person. I gave you a perfect example where the people had given the 50% to the group and gave that other 50% back to the other group, where their intention was really it was supposed to go to the other side of the family. Wrong person can just be an error too in names. Musings, people will do musings, I've seen in the will. Oh, well, that was just an idea. I'm like, well, don't put it in there. Bad or ambiguous language. I had one client I referred out to a lawyer who had been made the executor for an in-law, and the primary beneficiary had died, and so this was a person. The person who made the will was a chartered accountant who should have ought to known better, but said, "Oh, I'm a professional. I know what I'm doing." But in fact, they created one single line that was so ambiguous, and the effect of that was that we think it was supposed to go to the person named there, who also happened to be the executor. But what it did is it was like, but it wasn't clear enough, and it was that lack of clarity and definite gifting that exposed the will to allow somebody else to make a claim on the estate. And when I talked to that person, they're 6 or so months into it. At that point, they were already $12,000 into dealing with the lawyers and having to go to court, and they weren't done at that point. Missing key clauses. A really common one that I see is like people like, well, I don't understand that language. I'm just going to cross it out. I don't need that. And so they don't really realize the legal significance of certain clauses. A common one that I will see crossed out will be where you appoint an executor. Your executor is also your trustee, but you need to make them the trustee in your will. So you have to give everything that you have, all your assets and all your debts, in trust to them, and that makes them the trustee. So often we just say executor, but we need to make them the trustee. So I've seen that crossed out numerous times. So if you only have an executor and you don't have a trustee, that person doesn't have the ability to do anything with any of your assets. And so you cause some frustration to the terms of the will, and that would be a real challenge. And essentially all of these cost, right? And we're not talking small costs, we're talking minimum $5,000 to $7,000, and that's if you're lucky. There are elements of controlling from the grave that people want to give. They want to give something, but they don't really want to give it. They want to give something, but they want to wait. They want to give $100,000, let's say, to their son, but they don't want that son to get it until they're 45 years old. That really doesn't make sense. So first of all, that's a trust, but that also doesn't make sense because these can be challenged, because the people can put in some really unreasonable requests, or say, I'm giving this to that person, but they can't give it unless that person doesn't marry that person. I mean, yeah, people are interesting. I never have a dull day. I'm always amazed at the different stories and nuances I hear in and around that. Very common one is forgetting a contingency plan. So the what if. So okay, I'm going to appoint my husband, but what if we die together, or what if he dies before me and I'm incapacitated, then, or he's incapacitated and then I can't make another will? What if? Who's going to go in? Who's going to step in? Same thing with gifting. What if that gift of $2,000 you can't give to your niece, Mildred, and what if she's not there to be able to receive that gift? What if she predeceases you? Because the more people you name in a will, the more likely you're going to have some element of their lives causing some issue. And the common one would be them dying. So if you give them a gift, you want to be in control of where that gift going. So let's say it's $1 million and you're giving it to your daughter. But you're like, but what if she predeceases you? You want to make sure that that $1 million maybe goes to her kids. If you don't state that, then it's going to go to whoever her spouse is, and or maybe her children, but it's not going to go in accordance with what you would want. And so there is an element of keeping, a lot of people really generally want to keep their gifting in a bloodline, but most people don't give thought to these things, and they're just, I hear it all the time. I never thought about that. I didn't think about that. And so these are the conversations I have with people, are trying to root down to figure out what we need, what I need to know in order to make sure that I can create a will for you that's defensible and is the best representation of your objectives, and ideally gets to where it wants to go and mitigates any risk around potential will claims and variations. I mentioned trusts. Trusts are really easy to create in a will, but really complicated. If you create a trust that goes for 50 years, your executor who becomes your trustee would have to manage it for all of that time. But what if they can't? What if they die? So to summarize, that ultimately people just don't know what they don't know. They're not trained in these areas. So some of the risks for outcomes, which I've identified, but you can frustrate a will or certain terms of the will. So I'm going to give my 1965 convertible Mustang to my best friend Chuck, but Chuck died. So, and you sold the car. So if Chuck died, that's probably okay. But if you sold the car and Chuck's still alive, Chuck's not going to get that. And so, but you haven't identified a contingency plan. So if it exists at the time of my death, or in some cases, cars are a common one, we'll allow for whatever is my car or cars or vehicles at the time of my death will go to my granddaughter or my grandson, right? So we think about different terms and allow for some options to exist depending on a person's context and strength of conviction about giving that as a particular gift. Absolute, you can invalidate a will. You may, the will that you end up may not be the will you really wanted because you didn't really understand the implications of the language that you chose to use or didn't use, or you chose to, just trying to think. Sorry, lost my train of thought. That's okay, I was up till midnight last night. Anyhow, you can have a poorly executed estate because there's so many challenges with it. It can take time. Part of that poor execution can be related to the complications in an estate. Anything that requires going to court is obviously complicating it and is really challenging for all the parties concerned. One of the things that I do as a best practice is to register all the wills in the Vital Statistics Agency. There is a will registry, and it registers 5 key pieces of information. So your date of birth, your location of birth, the date that you've signed the will, and the location of the will. So you thought Mom made a will. She said she did, but you can't find it. So one of the, when you're doing probate, one of the required searches is of the will registry. So when a person does it themselves, you may not know that it exists. You may not know if it's revoked something else. You may not know that they have done some subsequent to that. So maybe they did a do-it-yourself will 10 years ago, but last year they chose me to do an updated will. You know, you might not ever know about that. There are elements of undue influence when people are doing their own wills. That's not that uncommon, where particularly with people who don't necessarily have kids, you know, an aunt or uncle who are elderly, lots of nieces and nephews can be quite motivated. We do know that 90% of abuse comes from families, and we do know that there is a rise in contention of wills because one, we have access to the internet and it's just much easier to do. People get information and they're like, I've got nothing to lose. And most lawyers will take anything on. So legal fees, I mentioned that earlier. I mentioned that you would expose a will to a different beneficiary. Again, a common one would be gifting to your son, but then he dies while he's in the middle of a divorce. They're not quite divorced, and it ends up going to their spouse who they were planning to leave, and that would not be what you would want. So that would be the wrong person as well. Will variation challenge, you're giving different amounts to different people, and you're like, oh, I don't like one of my kids as much as the other one, or this one's been nicer to me. Well, often there's a story in behind all of that, and so it's very easy to invoke a will variation challenge just by giving different amounts. But you know, so when we're doing them, things like, but I put, you know, we'll look at things like, well, why are you giving different amounts? In one case, maybe you put one of those kids through medical school, and they've had the advantage of an additional 300,000 of your wealth to get them through, but the other 4 kids haven't had that. So you might sort of choose to give them less or take into account those sorts of things. And just the other risk is huge. You know, any litigation or any challenges, emotions run high, family dynamics, but also grief. You know, people are dealing with grief. That's a hard enough emotion, and it's quite mixed in how it shows up. And that would be emphasized if you start having any problems in and around a will. Here's a really good, there's some good websites here if you're interested to look in and around this. Disinherited.com is an estate litigation lawyer out of Vancouver, Trevor Todd. He writes extensively, he speaks extensively. You just need to go in and poke in and around contesting estates, dysfunctional families, to see some of the issues that come up. He talks about different court decisions as well. So I encourage you to just take a look at that. If you want to get scared, go there. Who should not use a do-it-yourself kit? Blended families. A lot of people don't realize the challenges around a blended family. It's one that I personally have in my life, so I'm really well versed in that. But basically, as soon as you have a child from a different relationship, and this is not a stepchild, we're talking about your own child, that those have, you know, competing interests in terms of the Wills, Estates and Succession Act. So if you give everything to your spouse, but you don't consider your child from a different relationship, for whatever the reason, that person, that child could ask for a Wills variation claim. But this is complicated because you also have to look at how you've owned your assets with your spouse. So these are the sorts of things that you really need to be clear on. When you're planning to get married, there is language that we can use if that's what you're looking at. You have a common law spouse. Common law is probably the biggest aha most people get in the education that I provide while I'm doing my interviews. So for the Wills, Estates and Succession Act, common law is living with somebody in a marriage-like relationship for 2 years. And what marriage-like is kind of probably what we commonly would think that is, but you know, things are changing, and so really understanding what common law means, you know, and how you own assets with that common law. I've seen people recently who've been living together for less than 2 months who are calling themselves spouses. Not in this world. And so that matters in terms of who then becomes eligible to challenge your will. On the other part, it's like, oh, all of a sudden, you know, if you have $2 million in the bank and then you're with somebody after 2 years and you're like, well, I thought we were boyfriend, girlfriend with benefits, but yeah, we live together. That person is in a position to challenge your, to get a portion of your assets. So you really want to be clear on what that means. Separation always. Any advice around any choosing of executors or trustees, dealing with minor children, guardianship clauses, just even the overview of figuring out how to give things, because we talk in terms of objectives, so that's why we look at the world of what you own, your world. When you have other assets coming your way, because that may change what you have and how you have to give it. You have minor children or dependents with special needs. Any beneficiary who has special needs, who might have a registered disability savings plan, you need to see a lawyer for sure for that, because they can do special trusts. A lot of people can inadvertently give too much money and cause issues with their standard of living. And anybody who's aware of somebody or has somebody in their own family will understand it's very easy to upset the apple cart. So you need to see the right person to get the will done. If you've had a serious health diagnosis or recently been in the hospital, you know, there's some risk factors in and around that. Your health, you might be incredibly stressed, not thinking through things clearly. There may be some elements of parachute relatives coming in to help you because maybe they see a nice inheritance at the end of this. You may be subject to undue influence. So those are really important, that those people do not do their own wills. Family dynamics, I mean, without saying that one's clear. And beneficiaries or executors in other countries, I touched on that earlier about the US particularly, but you just need to be clear that that can impact them in different ways. Also, if you own recreational home, rental property, businesses is a big one. Lots of people have corporations, they don't really understand what that means in terms of their will, because they really need also separate corporate law advice. So seeing, depending on the complexity of the business, but seeing a lawyer who can also weave in education and documents that support your business in the event of a sudden death can be quite helpful. So do not do it yourself. Dual wills. You can have multiple wills, not in the same jurisdiction, but I've done wills for all of the world, excluding certain countries where people may have a will in that country. You want to forgive debts to children, or you don't want to forgive the debts to the children. So you gave one of your kids $50,000 to help them buy their house, and you never got around to doing that to the others for various reasons. You know, we can build in the law and the language into the document. Disinheriting, different amounts I talked about earlier. You don't want to leave money to someone who can't manage themselves. You want to save money is not a good reason to. That's why you should not use a do-it-yourself kit, because the legal implications are extensive, potentially. And the more you have, the more likely those will surface. You're in an urgent situation, for example, the health, but whatever that is, timely, having to go somewhere else. Or you have other contractual or obligations made in life that may affect your gifting here. So, common or a common one would be from a separation or a divorce agreement where you've had to give up certain pensions. So that may impact your gifting somewhere else, or give less, be able to give less to a subsequent spouse, things like that. So those are things that we understand. Some cohabitation agreements is something I'm actually thinking to do a session on, because they're quite fascinating. And I think it's a tool that people aren't aware of and should consider at length. Here's what happens if you die without a will. So this is a starting point. So I guess a will is better than no will. In some cases, no will is better than a do-it-yourself will. But essentially, it boils down to what the law would state you would want to do. But if you die without a will, you don't have a representative from the moment of your death. You have to get somebody who has to apply to become an administrator. That can take months. You don't have an immediate appointment for a guardian of your child. So, you know, who's going to decide who's the guardian of your minor child, right? The state? Probably. Distribution of the estate would be delayed. You haven't given thought to possible tax planning or different gifting strategies, taking advantage of everything. And you lose the opportunity to give to those that you want to give to. Wills are important tools. Appoints an executor, creates a trustee, gives away your assets, pays your debts, right? So it's the tool created within the context of a person's life. I say this all the time. Your will may be straightforward, but your life isn't. Blended families is a really good example. Challenged relationships, dynamics, estrangements, those things matter. Kids, you know, kids or somebody you haven't seen for a long time. I kind of have alluded to this all the way through. There we go. Oh, I'm missing some words here. What happened? Ah, cool. Okay, maybe it did work. Things I knew. So in BC, we have the Wills, Estates and Succession Act, and among other things, it defines the formalities required in a will, defines that we can have wills fixed. It defines who are legal beneficiaries, and that will depend on your context, and it defines who is considered a spouse, who I've said. These really matter to understand all of these things when you're creating a will. Why pay a professional? We're trained in drafting wills. We understand the legal language. We are insured. If there's a screw up, we have coverage for that. We really try not to do that, but we assess your capacity. We rule out undue influence. We look at the context of you and your family, the quality of the people that you're appointing as executors. We look at the big picture of how things are structured. We take into the consideration what your gifting intentions are, but also tax strategies that you've already set up, or you need to sort out with your financial peoples. And we get you to contemplate situations that you never thought about, and we offer different options. So in the end, the will may be straightforward, but your life isn't. So getting started, so this is just my way of getting started with clients. It gives you an idea. Years ago, I created a will questionnaire, and in mine, you'll see there's just some basic factual information on this first page, you know, particulars of your birth, your names. Knowing your different names really matters, because I'm going to say a minimum of 50% of the people I deal with on a daily basis all have some different version of their name. Some people use their second name as their common everyday name, and so some people will have 5 names, but you'll only see 3 of those names on different documents. So a lot of this really matters, particularly in and around real estate. And so what in my world, what this does, I make these available to clients and want them to fill them out ahead of time. But what it does is it allows me to go through and do my due diligence. It also allows you to start planning with the information that I'm going to need to know. Instead of coming and seeing a professional and then going away, it's like, oh, I wish I'd known that before. I wish I was more prepared. This allows for us to have successful experiences. This is part of the value. Not all practitioners do this, you know, but if they're using some sort of a guideline, it is also part of our note taking. In addition to this, you know, I take extensive notes. As a notary public, we're heavily trained in the area of wills and estates, and we're well versed in the Wills, Estates, and Succession Act. So we focus specifically in on these areas. And so one of the things that we know, in order to protect our clients to get the will that they want, and to have, if there's ever going to be a challenge to that will or any concerns around it, we've documented what you want. We've documented that you have full capacity. We've documented the different options. We've documented that you did consider that estranged child that you haven't seen for 15 years, and we documented why you haven't seen them for 15 years. Because you know what? You don't want to give them something because they chose to leave your life. You've made multiple attempts to stay in touch. You haven't met your grandkids. These are common stories I hear. And, you know, you've made efforts. And so these things matter in terms of if that person, that child, that estranged child were to ever come forward and say, look, I want my share of your estate after you're died. And you won't know it, you'll be dead. And so we do this in order to mitigate any risks after. Because I always say, people will say whatever they want. When there's money on the table, they'll say whatever they want after the fact. I have a low threshold, or a low belief that people will always do the good thing. So if you're looking for this, you don't have to come to me, but if this is helping you, if you have your own legal person, by all means, use this as your way of preparing to go see them. You'll also see I have my lunch and learns on there. We are open during COVID. And any questions from anybody? I see one coming up. Hang on. I'm going to go to the next. Whoa, I'm going to go to the next page. Yeah, here we go. I saw it. It went away. Hang on. Where did it go? Here we go. I got questions. Okay. So I have a question about, will I be repeating the session on health representations? I do not have anything scheduled at this point, but if we have your email, we can certainly send you the link to the ones that I do have. It is posted in a YouTube channel. So that, does anybody have any particular scenarios that they wanted to run past me? If you want, you can speak. I can give you the mic. Just give me a raise your hand or flag that for me. It's, you know, like I say, wills are straightforward. People's lives aren't. And I think I know some of you in this call, and I could say, yeah, that's probably true. But it's important. It's one of the best documents that you can do well. And, you know, just so you know, like, just basically my fees for a simple, straightforward will for a single person is $300. You can certainly, you know, go to other people may charge more, $500–600, but if you're seeing a lawyer, they may need to offer you different options, and it's well worth it compared to what it could cost otherwise. So I'm not really seeing any other any other questions. So and if you do call in, I mean, if it was me you wanted to see. So Robin, give me a call. I'm happy to talk to you about that. I do lots of blended family wills, and I understand the potential for the complications. Not all notaries will do blended families because of that, but I'm well versed in it. So it's really about knowing your options, knowing the laws, knowing the potentials, and mitigating those risks. You always have, as the testator, that's the old language. You are the current language is you are the will maker. So you always have you always have the testamentary authority to do the will that you want. That's what I aim to choose. And in some cases, no matter what you do in the will, it will get challenged, no matter how much you try to mitigate all of that. But, you know, you know, you can't change what will happen in the future, but there are strategies around mitigating it that you can do. Telling people what you're planning to do is one. So yeah, sorry that didn't go well for you. Can't think of anything else. It is a lot to cover. It's a really interesting topic. And again, as I was talking to my friend, the lawyer, said, yeah, it's an area of law when you get into a state litigation, they make lots of money because they're fixing not just a problem of the will, but they're delving into people's dynamics that sort of enhance or or lengthen the time that they need to work on it. So yes, I am in Victoria. I'm located near Mayfair Mall. So if there's any other, I will do a 10-minute phone calls, complimentary, depending on my schedule. But feel free to contact me. Thanks very much for joining in. Have a great day. Stay safe and healthy and positive. Bye for now.